there is no lawful notice and charge must be dismissed for failure to state an offense. Without lawful notice, there is no personal jurisdiction, and all proceedings prior to filing or proper trial document in compliance with the 7 elements is void. A lawful act is always legal, but many legal acts by government are often unlawful. Most bureaucrats lack elementary knowledge and incentive to comply with the mandates of constitutional due process. They will make mistakes, numbers beyond count, and have been convicted without benefit of government adherence to these 7 elements. Today, informations are being filed and prosecuted by accepted practice rather than due process of law. Jurisdiction, once challenged, is to be proven, not by the court, but by the party attempting to assert jurisdiction. The burden of proof of jurisdiction lies with the assertor. The court is only to rule on the sufficiency of the proof tendered. It's a whole lot of kind of difficult stuff to understand, but basically, if you're not served, if you're not informed of what's being alleged, and if there's not an injured party who's alleging the crime or the offense, there is no case. There is no case with this. There was no injured party. My kids were not abused. There is no report of abuse anywhere. They kidnapped our kids. There is no question. It's not a gray area. They kidnapped our kids. They had no cause. They used a forged document. They used a fraudulent, self-created, forged document that had no court information on it whatsoever. No name, no contact number, nothing. And then all of the hearings were over a speakerphone where no identification of the parties was ever done. I never knew who was even talking. They lied for 18 months saying that the person was an active judge in an active court of law, because I directly asked that question. Is this an active judge in an active court of law? And they lied for 18 months until I showed proof that they weren't judges. But still, nothing. They ignore it.